Hi, Freya.
Hi, Paula. I can hear you.
Good. I hope I don't have weird issues like I've been having.
You sound perfect, so you should be good.
Okay, well, so you witnessed this, Ben witnessed this. So if I have issues, tell the hearing examiner not to get upset with me. Like I'm doing my due diligence to try to not screw this up.
And I have experienced Teams issues with audio at other agencies, so I know it exists. It's not you.
Well, in fairness, my husband tells me I emit electromagnetic waves that like disrupt
Shut down.
technology. So, it could be me.
It could be you.
It could very well be me. So, anyway, appreciate you doing that. Thank you.
Of course. And I'm testing out some new headphones too, so it worked out perfectly. So thank
Hey,
you.
Freya, I want to say thank you for all the confusion caused with that filing issue, filing under the wrong person. Thank you for taking care of that.
Oh, no problem. I should have probably just left it alone. I created more issues by trying to fix it, but Kirk did send me the correct one today and it's good to go.
Perfect.
And did touch base with him this morning.
Good. Thank you. Yeah, I filed that while I was in Denver from a coffee shop. It was just we were not going to do that again. But thank you. I just want to say thank you for taking care of that. Thank you.
Of course. No problem. Okay.
See you guys
See
in
you
a little
guys
bit.
in a half an hour or so.
Freya, I see that we are recording, so I'm going to start this meeting at 8:57 a.m. Good morning. This is the first regularly scheduled docket for the OCD. We are hearing cases by affidavit this morning. And I'm going to ask Dean, our technical examiner, to make an announcement regarding the new exhibit to show who is voluntarily committed to a compulsory pooling case. So, Mr. McClure?
Mr. Hearing Examiner, I'm not seeing that he's on just yet.
Oh, okay. Will you let me know when he is?
I will. I just sent him a message.
Thank you. Do we have Jackie McLean and Michael Hall on this with us now?
I'm here.
I see you. Thank you. Mr. Hall? Freya, do you know if Mr. Hall is with us yet?
I don't see him either. I'm looking though.
That's fine. We did start a few minutes early. Oh, and I'll also make an announcement now that at 11:30 I need to take a lunch break. So if we're not done by 11:30, which probably a good chance we won't be, we'll come back on the record at 1:30. So we'll take a 2-hour lunch at 11:30.
Dean is on now.
Mr. McClure, would you
Yeah,
make,
Mr. Hearing Examiner, I'm here now.
good morning. Would you make that announcement to everyone about the exhibits to show voluntary commitment?
Yes, sir, Mr. Hearing Examiner. Just for everybody's awareness, as I'm sure most people are aware of, effective December 1st, we're going to start requiring a table that provides us with a record of who the operator is considering to be committed to the unit and the method with which they're being committed to the unit. I've noticed in all the, or a number of the exhibit packets that there may be some confusion as to where it should be placed within that exhibit packet. And so I just want to make everybody aware it was the division's intent for that to be a part of the landman exhibit packet that the landman is then addressing within their statement. And that was everything I had, Mr. Hearing Examiner.
All right, thank you. Do we have Mr. Hall?
He went down to Pecos Hall, not realizing it was virtual only. So he is logging in right now.
Thank you. Will you let me know when he's logged in, Freya?
Yes.
Mr. Hearing Officer, do you see me, hear me? Okay, sorry, my apologies.
Not a problem, sir. Okay, I'm going to call case number 1 on our docket. It is 25609. Entries of appearance, please.
Yes, Michael Hall on behalf of OCD here, Mr. Hearing Officer.
Good morning, Jackie McLean on behalf of LH Operating.
And Ms. McLean, have you entered an appearance yet?
We've had filed a continuance, an agreed upon a continuance with entry of appearance. So that's what we were using as the entry. We can separately file another one if you would.
Not necessary. So you're saying you did file an entry of appearance, and if not, you're entering your appearance now.
Correct.
That's good enough for me. So Mr. Hall, can you give me an overview of this case?
Sure. I think Ms. McLean will be able to probably get into more of the nitty-gritty details, but since this NOV was amended from a couple of years ago, there were substantial violations on behalf of LH Operating. Since the filing of the amended NOV, I've been in touch with Ms. McLean, and LH Operating is that in name only at this point. They have made changes in ownership, and they have taken substantial steps toward compliance as opposed to going backwards. And so that's the long and short of it. We're glad to see they're making progress. I'm familiar with the new owner. I believe it's Eon, and they're a big outfit that generally does things in the proper manner. And so I agreed to the continuance, really in 2 parts. One, because I was in a 3-week hearing and didn't have the resources or ability to really focus on this matter like I'd want. Given the progress, Ms. McLean and I agreed to continue this until January, so we had some time to negotiate, given the holidays, that kind of stuff, and see if we could reach a resolution, kind of given the new posture of LH Operating. It's been positive, substantial changes, both in reporting and dealing with inactive wells. And so OCD is really glad to see that. I want to see that progress continue and give them a chance to negotiate with us to try to find a resolution to this matter without a contested hearing. So that's essentially OCD's position on this.
Thank you, Mr. Hall. Ms. McLean,
Yes,
I have some questions for you about this case. What was the nature? From what I understood from Mr. Hall, there was an initial NOV sent out several years ago, and then there was something else that was sent out more recently. Is that the idea?
Yes, that's correct. So I think 2 or 3 years ago, and I wasn't involved at that point, the OCD had sent an NOV to LH Operating. Well, in the midst of that, LH Operating sold all of its assets to Eon. They did not disclose the NOV. So Eon was just, going about their business and what their plans were for those assets. When this fall, they received the amended NOV, and they acted on it very quickly. We reached out to Michael, Mr. Hall at the OCD, and told him, we weren't aware of this. Here's what we've done so far. And in the midst of all this, they're also conducting kind of a self-audit to make sure that they are totally in compliance and up to date on all the required filings. So that's part of the reason why we requested the continuance, was just so we could present the OCD with all of the information before we discuss a settlement. I'm actually meeting with them tomorrow to go over all the findings, and then I was going to reach out to Mr. Hall to set up a meeting.
What is the nature? So Mr. Hall, has the nature of the allegations changed from the original NOV to the amended NOV?
Yes, and since the amended NOV, that has also changed. And so they were going backwards at the time of the filing of the amended NOV. I think that's because Eon hadn't gotten a grip on some of the non-compliance yet. Since the filing of the amended NOV, there has been positive progress in terms of reporting and in terms of well plugging or bringing wells back online. And so again, oh, excuse me.
Mr.
Yes, sir.
Hall,
Yes, sir.
I'm trying to understand the nature of the NOVs. So let's just talk about the amended, not the original NOV. What
Okay.
are the general allegations in the amended NOV?
General allegations are too many inactive wells. That's pretty much it.
Inactive
I can
wells.
pull it up. There may be a little more, but that was OCD's primary concern.
And was there a civil penalty included?
The proposed civil penalty, yes, sir.
Which is what?
I believe it was 300,000. I don't have it
Okay.
in front of me. Let me pull it up. I'm happy to. I have a draft of it. I apologize for not. I was running around to the wrong places, and so. But yeah, I'll. Let me find that, and I will get it. It's. I believe it's attached. But yes, and that. I mean, that would of course be part of the negotiation. You know, that's we would still want civil penalties, but again, I mean, the posture's slightly different, whatever that amount is, which I'm looking for, but the posture is different given it's a new company that's LH operating in name only. That is, it's doing what the state of New Mexico wants. It's bringing the wells back into compliance. That's the purpose of these NOVs in my mind. And so anyway, that's there should still be consequences in our mind for the non-compliance, and Eon has bought LH operating, and that doesn't change that past non-compliance, but we're very pleased to see a positive path forward. So
what was the fine?
I'm looking. Excuse me. I was talking. So let me pull that up.
Okay, Mr. Hall, while you're looking, Ms. McLean, how many wells were alleged to be out of compliance?
Oh my goodness, I think it was like 500.
Are you serious? 500?
Or 300, yeah. And I'm sorry, let me get the exact number, because I have all these Excel spreadsheets with new information. And I believe, okay, so I can tell you that. Oh, sorry.
No, I'm interrupting you. I'm apologizing. I have a draft. Let me just find the one that was signed by the director, and that'll be definitive. I want to say it was actually 117 inactive wells.
Yeah, 117.
Okay.
They operate 549 wells, and there's 117 wells that are out of compliance, and the civil penalty is $366,300.
Perfect. That's what I wanted to know. Thank you. I appreciate the information. All right. So the parties have requested a continuance to January. And at that time, either there'll be a settlement agreement and we won't have to hear the case, or there won't be a settlement agreement and we will hear the case. Mr. Hall, if we hear the case, how many witnesses will you have?
Just one that I'm aware of, Mr. Hearing Officer.
So it will be.
So I believe it will be Rob Jackson. It will be someone from admin. Nicholas also worked on civil penalty matters, but my understanding is he might not be in our employ anymore. And so exactly. So I apologize for the uncertainty. Rob would be the safer bet, I think, on that. In the event we need a witness.
Okay, and you'll have Mr. Jackson could probably testify to some of what you need, but you may also need someone to testify to the notice and to other clerical issues. That's what we've done in the past.
Sure, and if in the event, yes, that won't be hard. I believe Sarah Griego could testify to notice. So
that's right. So as in the past. Okay.
Yes.
All right, Mr. Hall. So we'll continue this case. What I'd like to hear from the parties, since we are continuing it for 2 months now, And Mr. Hall, before I forget, what date did you send out this amended NOV?
Oh gosh, I'll have to. Do you have it there, Jackie? Since you had all the.
September 18th.
Perfect. Thank you. Excellent. Okay.
Thank you.
So, Mr. Hall,
Mhm.
I won't be inclined to grant another continuance. So
Okay.
please be prepared to either move forward with the case at that time or dismiss it and attach something that says you've reached an agreement with Miss McLean and her client.
Happy to. Thank you
All
for.
right. Sounds good.
Yeah,
Anything
thank you
further,
for-
Miss McLean?
No, I will pop off and I'll be back.
Sounds good. Good luck
Thank
with the
you.
commission. Okay. Mr. Hall, anything further on this case?
No, thank you for your time and my apologies for being for not understanding that it was only virtual. So
Excellent. Thanks
Okay.
for your time, Mr. Hall. We're off the
Thank
record
you.
in that case.
Thank you.
Let's
May I
call
be
case
excused?
number 2.
Okay.
This is Oxy USA 25519. Entries of appearance, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Oxy USA.
Good morning.
And I believe
Is it
Miss,
Kessler?
yes.
Yeah, okay. I won't. Oh, well, I think she's there.
Good morning, Mr. Examiner. I'm having a mic issue. Can you hear me?
I can hear you.
Wonderful. Good morning. This is Jordan
Morning.
Kessler on behalf of EOG.
Thank you. And your position is no objections?
Simply monitoring. Yes.
Perfect. Thank you very much, Ms. Kessler. Ms. Vance, go ahead.
Yes. So we have previously presented this case. We did a amended follow-up at the October hearing. And then it was at the October hearing that we discussed filing an amended application.
Okay.
So we filed the amended application. We completed the notice.
Okay.
And I'm happy to just show very quickly where you can see. Oh, okay. Not a problem.
Not necessary.
All
The
right.
technical, let's just get your everything into evidence. Is there anything new to admit into evidence?
We included the amended application and then the notice to go along with
Okay.
that. So my self-affirmed statement, sample notice letter, and then the NOP, affidavit of notice of publication. So that's included and it's all timely.
And they're all timely. Okay. I
Yes.
know that Mr. McClure has reviewed this case. I just have one question for you myself before we take it under advisement. What was the problem? What was the defect in the notice?
So we just did not have the full project area. And you'll see if you look at the hearing packet, I highlighted it. I made sure it was clear. So
in other words, the initial application was for a small, you noticed a smaller area than you should have? Okay.
that's correct. So one of the wells, it's part of an enlarged spacing unit. And when I did when I wrote out the project area, I limited it to just the well rather than the full spacing unit. So I just corrected that.
All right. Then we will accept your exhibits without objection and take your case under advisement. Thank you very
Thank you.
much.
Thank you.
We're off the record. Moving on to Matador Production, we have 2 cases here, 25533, 25534.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Matador Production Company. And I don't believe there are any other parties included. Or no, I could. I'm wrong. Sorry, I have a lot of cases today.
Paula, you are doing fine. Good morning, Mr. Examiner. This is Carrie Hatley, entering her appearance on behalf of COG Operating and Concho Oil and Gas, and we are monitoring only.
Perfect. Thank you, Ms. Hatley. Ms. Vance.
Thank you. So these are just extension applications and requests. So we have included in our hearing packets a copy of the application, the original orders which were issued on August 4th, 2023. We've also included the the affidavit of our landman, Clay Wooten, who has previously appeared before the division, and his credentials have been accepted as a matter of record. We did include an updated pooling exhibit because Matador acquired 2 of the interests, and so that's noted in the updated pooling exhibit. And then following that is my self-affirmed statement of notice with a sample copy of the letter that went out on August 22nd, 2025, and then an affidavit of notice of publication, which was timely. published on August 26, 2025. So unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement at this time.
And Ms. Vance, this is a second year extension, right?
That's correct.
All right, very good.
And
All right.
I was just going to say there's some information, some color on that in the landman statement as to why
Sure.
there's the good cause and request for the extension.
And you have your landman available?
I do.
All right. First of all, we'll accept your exhibits into evidence without objection. And Mr. McClure, you have a question for the landman?
Yes, I do, Mr. Hearing Examiner. And if I may, I'd like to ask a quick clarifying question for Ms. Vance.
Please.
Ms. Vance, just to make sure I heard you correctly, did you say that you were removing pooled parties or that you were adding pooled parties?
Removing two pooled parties.
Okay, thank you, Ms. Vance. Thank you, Mr. Hearing Examiner. I'm ready for the landman whenever we're ready.
Ms. Vance?
Yes. Let me see. Clay? There he is.
Mr. Wooten, would you wait? It says Isaac Evans, but that's not correct, is it?
Yeah, we're all in the same room here at the Matador office. We're all logged in under Isaac's.
Okay. All right. Would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Please spell your name.
Clay Wooten. It's ClayWooten.
All right, great. You can put your hand down. Thank you. And you've been accepted as an expert before this division?
Yes, sir.
In what field?
Landman, petroleum
Perfect.
landman.
Thank you. Mr. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Wooten, I'm looking at your landman statement on page 15 of 28. Specifically, I'm looking at like your paragraph 6 here. Are you with me, sir?
Yes.
Okay, within this paragraph, you reference that Matador was looking to evaluate production from 2 offset wells. Is that correct?
Yes.
So then it is correct that those 2 wells have been producing, and Matador has gathered the production data that it was wishing to seek. Is that correct?
Yes.
Okay. Later on in this, well, let me back up a bit. So of that production data that Matador observed, it does intend to drill out all of the wells that was proposed within this order. Is that correct?
We're going to drill the 120 series, so the 121, 122, 123, and 124. That's the plan.
Let me scroll up to the CPAC. And you referenced only the 120 wells? It looks like there's 110 wells and a 130 well as well. Is that correct, Mr. Wooten?
Yes, for the near term, it's going to be the 120 series here in the next few months.
Oh, okay. That was actually where I was getting ready to go, because I noticed in this paragraph 6 that you referenced that within the next few wells, Matador was going to drill a few of the wells. And what you're referring to was the 110 wells then. Is that correct?
The 120 wells.
Excuse me. I think that's probably what you just said. So is the thought process that within the next year, Matador intends to drill all of the wells, though?
I'm not sure what our plans are for these additional wells just now.
So then is it going to be Matador's intent to ask for a 3rd extension then within the next year?
I think I'll defer to our counsel on the 120 series holding the order.
Well, I was gonna say your counsel isn't under oath. Mr. Hearing Examiner, do we want to ask Ms. Vance that real fast, or what's your thoughts?
Hold on one second. Let me think about this. So what was the question, Mr. McClure?
Oh, my question was whether Matador intends to drill out all the wells, all the dedicated wells for the unit within the next year, or if they plan on asking for a third extension request before the year's out.
And Ms. Vance, what did you want to say?
So I think what Mr. McClure is getting at is that the new notice that came out from the division requiring all wells to be drilled under a pooling order. However, what I would say, and we have confirmed with the division's in-house counsel, is the effective date of that notice was June 1st, 2024. These orders were issued in 2023. Prior to that notice coming out in 2024, it was you would need to drill one initial well that was under the order to perfect it. And so these orders follow under that interpretation.
Mr. McClure, does that help you, or do you still have further questions?
Well, Mr. Hearing Examiner, I don't know as our announcement clarifying the intent of the order makes it so I no longer have this question for Matador. And so I'd like Matador to address it, regardless of an announcement about the intent of an ordering paragraph that's been in the orders for a while now.
All right. So, Ms. Vance, I don't know if you want to talk to your witness offline. We can come back on this case if you prefer. But Mr. McClure wants an answer to this question. And if you counsel your witness not to answer the question, it's your right to do that. But it may not give Mr. McClure enough information to approve the amendment. So I think you might want to talk to your client offline.
Yes, if you wouldn't mind, but also I would say I have a lot of cases. So it may be during that lunch break, that I do that, if that's okay.
Okay. Well,
yeah.
the next case, Ms. Vance, is Mr. Bruce's case. Do you need more time than that to talk to your client?
I'm gonna try and make it work.
Perfect. And if not, that's fine. We'll figure it out as we go along. I want to give you time to talk to your client.
I appreciate that. Thank you.
So we're going to be off the record in those two Matador cases. I'm now going to call case number 25573, Mewborn Oil.
Mr. Examiner, Jim Bruce representing the applicant.
Okay.
Mr. Examiner, in this case, Mewborn seeks to force pool the south half of both of sections 8 and 9, 22 south, 27 east, which is in or near Carlsbad, and that comes into play in just a minute. This case was presented 6 or 8 weeks ago and was continued. There were some specific requests from the technical examiner, and one of them involved the land plats, which are, well, let me get to that. So anyway, the case has been continued. I have submitted the second revision to the exhibits. Some of the revisions are really just housekeeping matters, like Exhibit 4. The certified notice was updated to show what happened to all of the certified mail. Exhibit 5, originally at the hearing, I did not have the actual affidavit of publication in the newspaper, and that has been added in. One of the requests by Mr. McClure was to correct the pool and pool code on the pooling checklist, which has been done. And then you get to the heart of the matter. Mr. McClure wanted tract maps showing each tract and the interest owners in each tract. That leads to complications which are reflected in the landman's affidavit, particularly paragraph 5 of Exhibit 3. And then the land plats, which have been included as part of exhibit. Okay, exhibit 2A. This land was never subdivided by quarter sections or multiples thereof by the federal government, which is shown by the only BLM plat of the entire township, marked exhibit 2A1. Instead, this was patented out as small tracts, which were then further subdivided. And the lands involved in the only interest owners being forest pooled, who form less than, I think it's 0.04% total of the entire well unit, are in lot 11 of block 12 of the plat of the Riverside Farms subdivision. And that is exhibit 2A2. And just that land alone, there are 19 tracts, and the entire well unit is covered by these small tracts. Some of the tracts are larger than lot 11 of block 6, but nonetheless, if Mewburn was going to submit plats on this, just this one little block 6 of Riverside Farms, you'd have, 10 or 20 pages of descriptions of the land involved and the interest owners involved, which, if you multiply that out by the number of subdivisions, small, not governmental subdivisions, but subdivisions into these old, they're usually called river tracts, river subdivisions, would lead to dozens and dozens and dozens, at least, of pages of tracts and the interest ownership. And then when you see exhibit 2A3, you see that this small tract is part of the southwest quarter of section 8, which probably isn't scaled to size, but you can see that this whole 320 acres is broken down into these small tracts, and it just becomes impractical for the information the division needs. And exhibit 2B does contain a list of all interest owners in the well unit, and only 4 of them are being forest pooled, and their total interest being pooled is 0.3857% of the
Mr.
total
Bruce?
interest.
Mr. Bruce?
In it. So that's
Mr. Bruce?
the land.
Can you hear me,
where,
Mr. Bruce? Hello, Mr. Bruce.
Yes,
Can you hear me?
Yes, Mr. Examiner.
Oh, that's great. I'm not sure that you need to go on this long about this. Do you want to sum this up in a sentence or two so we can accept your exhibits and see if there's any questions?
Yes, it's just doing the track by track, which you normally do, where it's subdivided into quarter sections and multiples thereof, leads to a page, an exhibit 2, 3, 4 pages long. And this particular one, doing that, it would be 20 or 30 or 40 pages long. So it's impractical. And so I'd move the admission of exhibits 1 through 6, and the landman is on the line.
Perfect. Thank you, Mr. Bruce. Without exception, Mr. McClure, do you have any questions for the landman?
No questions, Mr. Hearing Examiner.
Very good. Mr. Bruce will take this case under advisement.
Thank you, sir.
Okay. Ms. Vance, has that enough time for you? Okay,
Good.
very good.
We're good
Let's
to
go
go.
back. Okay, thank you. Let's go back on the record, 25533 and 34. So, Ms. Vance, is your witness still available?
Yes, he is. And should
I see
be
him.
popping. Okay,
I see him.
good.
Mr. Wooten, okay, Mr. McClure, go right ahead.
Thank you, Mr. Hearing Examiner. Mr. Woodton, is it Matador's intent to drill all of the wells that's dedicated to this unit within the next year?
I'm not sure about all of them. I just know the 120 series is more near term. And if the commission is going to require us to file a third extension, we will.
Has the data that Matador's gathered so far been sufficient to make a determination about the other series of wells?
The data they were monitoring was specifically that second bone formation. And they drilled the 125 and 126 last year, and we're monitoring results from those to drill the second bone up here in these, the 121 through 124.
Okay, so within the next year, will Matador have enough information to determine if it wishes to drill the rest of the wells?
I'm not really sure. That's not my expertise.
Okay, thank you, Mr. Wharton. Thank you, Mr. Hearing Examiner. I have no further questions for these cases.
For these cases, okay, very good. All right, thank you, Ms. Vance. We'll take these cases under advisement.
Thank you.
We're off the record.
Sorry.
All right, let's move on to some more of Ms. Vance's cases. Matador Production Company 25583 and 84.
Good morning, Mr. Hearing Examiner, Mr. McClure, Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Matador Production Company. And these are pulling additional interest owners. I don't believe there's any other people in these cases, so happy to move forward. So like I said, these two cases are pulling additional interest owners. We've included in our hearing packet a copy of the application file, the original orders, which were issued on October 31st, 2023. Our landman is Reese Clark, who has previously testified before the division, and his credentials have been accepted as a matter of record. We have Mr. Clark's land statement, a land track map, a pooling exhibit, as well as a sample proposal and AFEs that went out, in a chronology of contacts. And then following that is my self-affirmed statement of notice with a sample letter that was timely mailed on August 22nd, 2025, and the affidavit of notice of publication, which was timely published on August 26th, 2025. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record, and that these two cases be taken under advisement at this time.
Thank you. Without exception. Mr. McClure, questions on these two cases?
Mr. Hearing Examiner, I will have a question for the landman for one of these cases.
Okay, so Ms. Vance, it looks like we're taking case 25583 under advisement, and we have questions for your landman on 84. I see someone there. Who is it?
Yes, this is Reese Clark.
I'm sorry, it's who?
Yes, this is Reese Clark for Matador.
Reese Clark. Ms. Vance, has Reese Clark been qualified as an expert?
Yes, and I thought I stated that, but yes, he has previously testified and his credentials have been accepted as a matter of record.
Okay, I'm not familiar with his name, and I don't believe I've ever questioned him before. But Mr. Clark, would you raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yeah.
Please spell your name for the record.
ReeCeclark.
Great. You can put your hand down. As Ms. Vance stated before, have you been accepted as an expert before this division?
That's correct.
When was that?
Back in 2023.
Oh, okay. Back in 2023. All right. And in what field?
Petroleum landman.
All right. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Clark, I'm looking at your summary of interest table under Exhibit C2 on page 19 of 44.
Okay.
Here it looks like we have two different persons that's highlighted yellow. Do you see where I'm referring to?
Yes,
Is Matador asking the division to force pull both of these persons?
that's correct.
Okay, was Binco Energy Incorporated provided notice of this case?
I believe so, but I'm going to defer to Ms. Vance on that one.
Mr. Hearing Examiner, it would, the notice would fall under the attorney's statement. So you think it's appropriate for me to ask Ms. Vance this question, correct?
I do. Do you have any other questions for Mr. Clark before we go to Ms. Vance?
Yeah, good point. I do not have any further questions for Mr.
Okay, very
Clark.
good. Thank you, Mr. Clark. Go ahead with Ms. Vance, please.
Ms. Vance, are you aware of whether Binco was provided notice of this application?
I'm looking at our notice specific to this case, and it looks like it was just the one party. So it seems that we'll need to provide notice to Banco and then come back.
So, Ms. Vance, how much time do you need before we can hear this case again?
I would have to do the calculation. We can get the notice out today and
Right.
get we'll send it out today.
Right.
And presumably, let me just check one thing because okay. Yeah, we will get the notice out today and I will get the NOP run today. I think that probably if we do that, we would be ready mid-December. So I'm not sure. I don't remember when is the status conference. If the division would allow us to come back before the new year to be able to perfect notice, we'd be appreciative
Okay.
at the 12/18 status conference, or if there is a contested hearing special docket later in the month, we would appreciate some time to just perfect notice at that point.
So when it's specific notice this way, I believe it's 20 days, is it not?
Well, it's 20 days, but as a backup, we always do the
Publish.
NOP. Yeah.
Okay. Which is shorter. It's 10 days for the NOP, right?
10 business days, correct.
Right.
But we do have a lot of holidays.
Okay. Well, it seems like we would have time on the December 9. I think it's 9. No, maybe not. Hold on. December 4 docket, wouldn't there?
Would that give us enough time? Yeah, that gives us enough time.
I would think so. If you send it out today and publish today. Yeah.
I'm not sure when the newspaper will be able to run it, but certainly it's plenty of time to get it done. So we would be ready to come back at the 12/4 docket if the division will allow us to do that.
The interesting thing is when I count the days between today and then and not count today, because you can't count today, and then there's a holiday, as you said. I don't know if the holiday is 1 day or 2 days. It might actually be better to put it on the December 9 special docket and not try to get it on the 4th. It seems like it's cutting it too close.
I think that I would appreciate that. So,
okay. All right.
Yeah.
Well, I'll leave it to you to continue it to the December 9 special docket. We'll hear it first before any other cases. Now, if that docket is canceled, we'll have to move it to some other docket.
Understood.
All right. All right. Good luck with your notice. Anything else, Mr. McClure?
Nothing from me, Mr. Examiner.
All right. Anything else, Ms. Vance?
No.
All right. Thank you. We're off the record in that case. All right. Let's move on now to some more Ms. Vance's cases. Matador Production, there's going to be about 4 or 5 cases here. 25585, 86, 87, 88.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe Office of Holland and Hart on behalf of the applicant, Matador Production Company. And again, I don't believe that there are any other parties in these cases. And so I'll move forward. In these cases, Matador is seeking to pool a record title owner for purposes of getting the federal CA completed and approved. In the hearing packet, we have included a copy of the application, or in each of the hearing packets, we've included a copy of the application, the original orders, each of which was issued on December 23rd, 2022. We've also included a statement from our landman, Hawks Holder, who has previously testified before the division, and his credentials have been accepted as a matter of record. We've included with his as sub-exhibits a land track map, pooling exhibit, and then a chronology of contacts, I believe. And then a self-affirmed statement from myself regarding the notice, a sample copy of the notice that went out on August 22nd, 2025, and then an affidavit of notice of publication, which was timely published on August 26th, 2025. Unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement at this time.
Thank you, Ms. Vance. They're accepted into evidence without objection. Is this the second or third extension?
This is not an extension, it's just pooling record title owner.
So the amendment has nothing to do with an extension. Okay, I understand. All right.
That's correct.
Okay, I believe Mr. McClure has reviewed these cases. I don't believe he has any questions here, so we'll take these cases under advisement.
Perfect, thank you.
Let's move on now to EOG Resources, two cases at lines 12 and 13 on our docket, 25627 and 28. Ms. Vance, are these your cases?
I got ahead of myself. I thought I had a break.
Nope.
I'm so sorry. Good morning, Mr. Hearing Examiner, Mr. McClure, Paula Vance with the Santa Fe Office of Holland and Hart on behalf of the applicant EOG Resources.
Good morning, everyone. Dina Bennett with Model Sperling on behalf of Avant Operating 2. And we entered an appearance in the case. We're monitoring only, and Ms. Vance and I have had a chance to discuss, and she'll be providing an update during her presentation.
An update about what?
About Avant and EOG's discussion, negotiations. I'm happy to provide the update as well, too, but.
Okay, but you don't have an objection?
No, no objection.
Okay, very good.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of COG Operating, and we're monitoring only.
Thank you.
Good morning, Mr. Examiner. Jacob Everhart, that's EVERHART, with Beatty Wozniak, New Mexico, appearing on behalf of XTO Permian Operating. For monitoring purposes only and to preserve rights, we are not objecting.
Perfect. Thank you. Ms. Vance?
Thank you very much. So in both of these cases, it involves the same overlapping acreage. So it's a 1,280 acre non-standard spacing in both of the cases, and EOG will be applying separately for administrative approval of the non-standard spacing units. In both cases, the acreage is all of sections 12 and 13, and that's in Township 20 South, Range 32 East, and that's in Lee County, New Mexico. So in case number 25627, the pool there is the Salt Lake Bone Spring Pool, and the pool code is 53560. And EOG seeks to initially dedicate that spacing unit to the Margie 24 Federal Com 501H, 551H, 502H, 503H, 504, 505, 506, 515, 512, 513, and 514H. And then in case number 25628, the pool there is the Hat Mesa Wolf Camp pool, and the pool code is 96438. And EOG seeks to initially dedicate that spacing unit to the Margie 24 Federal Com 701H through 705H. In each of the hearing packets, we have included we've included a copy of the application, the compulsory pooling checklist, along with the self-affirmed statement of our landman, Lacey Stretcher, who has previously testified before the division, and her credentials have been accepted as a matter of record. We have the C102s. Well, we've got all of the standard sub exhibits. I won't bore you with listing them all out. And then we have our geologist statement, Ms. Tara George, who has previously testified before the division, and her credentials have been accepted as a matter of record. Again, all of the standard geology exhibits. We did test out the new evidentiary notice exhibit, and we included it with my notice and not with the landman's exhibit. So noted for next time, Mr. McClure. So we've got along with the evidentiary notice exhibit, we have a sample copy, my self-affirmed statement of notice, along with a sample copy of the letter that went out, which was timely mailed September 19th, 2025. And then following that is the affidavit of notice of publication, which was timely published. One notice went out, or one affidavit was September 24th, 2025, and we did a follow-up October 26th, 2025 notice of publication. So unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement at this time. That being said, we do plan to Ms. Bennett's point earlier, EOG has reached agreement with Avant, and so we do plan to file an updated revised hearing packet to reflect that they are no longer being pooled. And so we expect to do that after the hearing. Again, unless there are any questions, I would ask that the exhibits and sub-exhibits, or if you want to wait for the revised hearing packet, that they be admitted into the record.
So Ms. Vance, couple questions. This revised hearing packet, is it for both cases or just one?
Both cases.
All right. I think Mr. McClure has some questions on case 28. So there may be some more revisions coming. So Mr. McClure, well, first of all, let me admit what we have now entered as exhibits into evidence without any objection, right, Ms. Bennett?
No objection so long as they are updated to reflect that Avant is not being pooled.
So there's a conditional objection then, it sounds like.
Yes, a conditional objection.
All right.
Thank you.
Mr. Eberhardt?
Mr. Examiner, no objection here.
You turned your camera on, that's why I called on you.
Apologies.
No, not a problem. I just didn't know why you turned it on. All right. So Mr. McClure, the exhibits as they currently exist have been admitted. Who do you have questions for?
Only for Ms. Vance, Mr. Hearing
Oh,
Examiner.
go right ahead, please.
Ms. Vance, for both of these cases, it looks like maybe written notice was conducted on September 19th, then again on October 24th. Is that accurate?
That is correct.
Okay. What was the, very briefly, what was the underlying reason for the second notice?
I'm looking to see, I believe there was an updated. Yes, so there were 3 additional parties that we needed to provide notice to, and you can see the tracking report. Sorry, typically I have the dates on our tracking report. If you go to page 78 of 80, at least on the 27 case, 25627, that's the additional notice that went out.
Yeah, I'm looking at the other case. Let me open up this case.
I can tell you on that one as well.
Okay, I do see there's 80 pages, and you said it was on 76, is that right?
78, and then on the other packet, it's 65 of 67. It's those 3 parties were the additional notice that went out.
Okay, and see, that was actually what my follow-up question was going to be as well, was
and you'll see there's 2 NOPs to reflect the 2 different times we did the notice.
Yeah, very good. And I guess my only question then was, and just to confirm what you just kind of laid out to me then, is there's the list of 3 persons that's on the last page of the notice spreadsheet. That is for the second notice, and the rest of it was for the first notice. Is that correct?
That's correct.
Okay. Also, just to draw your attention for case 628 to your CPAC. In the copy that we have, it appears that your signature is not there. So when you submit your amended exhibit packet, if we could rectify that as well. I have no more questions, Mr. Hearing Examiner.
All right, thank you. So Ms. Bennett, did you have anything further?
No, I don't. Thank you very much.
All right, sounds good. Mr. Everhart?
No, sir, I do not.
All right. So Ms. Vance, when do you want to bring this case back around?
Well, it shouldn't take that long to get these revised hearing packets filed. So whenever the earliest opportunity to come back to the division.
All right. And that's both cases, right, Mr. McClure?
Well, it's the one case for the extinguisher, then both cases for the removal of Avant.
That's right. That's right. Okay, very good. So both cases need to come back around. When we're considering, Ms. Vance, having another docket on next Tuesday. There are many cases here that need to come back around, unfortunately. And we're trying to keep these cases from bumping other cases off the December 9, or excuse me, I keep saying December 9, December 4 docket, because we're going to get too far out there. So but we do need time for Mr. McClure to review the additional documentation. So if you're able to commit to submitting these revised exhibit packets by close of business tomorrow, Friday, the 14th of November, we can hear them on November 18th.
I can do that.
You can do that. Okay. We haven't decided what time to start on the 18th. We might not start until later in the morning to give Mr. McClure a little bit additional time, depending on how many cases there are, but we'll send out notice for that.
I appreciate that.
All right. So November 18 for both of these cases. We're off the record. Thank you. Calling Mewbourne Oil 25634.
Good morning, Jackie McLean on behalf of Mewbourne Oil Company.
Good morning, Mr. Examiner, Dina Bennett on behalf of Avant Operating 2. And we did originally object to the case proceeding by affidavit, but on November 3rd, we withdrew our objection and are now monitoring.
Perfect. Thank you, Ms. Bennett.
Good morning, Mr. Examiner. Carrie Hatley on behalf of Burlington Resources. We entered an appearance, but we withdrew it 2 days ago, so we are no longer in this case. Thank you, sir.
Thank you, Ms. Hatley. All right. Ms. McLean.
Yes, thank you. In case number 25634, Mewbourne seeks an order pulling all uncommitted interest in the second Bone Spring interval of the Bone Spring formation, underlying an 876.42 acre, more or less, non-standard horizontal spacing unit, comprised of the north half of section 19, township 18 south, range 30 east, the north half of section 24, township 18 south, range 29 east, and the north half of section 23, excluding the east half northeast quarter of township 18 south, range 29 east in Eddy County. And this unit will be, yes.
Sorry to interrupt you, but let's talk about that excluding for just a moment. Okay. Can you bring up, can you share your screen and bring up a map of this area?
So I can bring up our exhibits, which can show you that exclusion area, the non-perf zone, basically. I'm happy to do that. Give me 1 second.
Sounds good. Thank you. You know, let's take a 5-minute break and I'll be back at 10 o'clock. So 4-minute break. Thank you, Ms. McLean.
Okay.
All right, Ms. McLean, are you ready?
I'm ready. Let me share.
Thank you.
All right, are you able to see this map?
Perfectly.
This is Exhibit A2,
Perfectly.
and this shows up here the location of the wells, and in the blue shading is that exclusion, no perf zone. We also have on the C102 that is reflected here in this plat. And that's with the red dotted area would be the no perf zone.
So, Ms. McLean, can you make a brief legal argument how the division can approve this with the no perf zone?
Well, we have separately applied administratively for a non-standard spacing unit. And so I believe that that is how this works, is with that approval of the non-standard spacing unit. It is still pending before the division. We've passed the 20-day objection period. That's cleared, and now we're just waiting for that approval.
All right, thank you. All right. So we'll deal with any questions about that when it's time for Mr. McClure. So please proceed with your presentation.
Thank you. Do you want me to continue sharing, or should I stop?
No,
or what?
you can stop sharing for now. Thank you.
Okay. Just want to make sure.
Mhm.
Okay, so I believe that I was just giving you the legal description and
Yes.
The excluded acreage that Mewburn is proposing for this no perf zone, and the spacing unit will be dedicated to the IOU wells. Like I said, we've separately requested administrative approval of the non-standard spacing unit and are waiting on that. Our exhibits were submitted timely for this case and include the land testimony and exhibits of Braxton Blanford, who has been previously admitted to testify as an expert in petroleum land matters, as well as geology testimony and exhibits from Charlie Crosby, who has also previously been admitted to testify as an expert geologist before the division. We've also included our notice testimony along with copies of the notice letter, which was timely sent to all parties on September 10th, 2025. And we published on September 18th, 2025. With that, it sounds like there will be questions, so we are happy to take those, but I asked for the exhibits to be admitted into case number 25634.
Thank you. Without objection, Mr. McClure.
Thank you, Mr. Hearing Examiner. I will have questions for the landman.
And who is your landman, Ms. McLean?
Braxton Blanford, and I believe
Great.
he is on.
Morning.
Good morning. Please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, great. You can put your hand down. Thank you. Will you spell your name, please?
Braxton, Braxton, Blanford, Blandford.
All right, perfect. And I recognize you, so I know you have been qualified as an expert in what field, sir?
Petroleum land.
Okay, Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Blanford, has a discussion with the BLM taken place in regards to this exclusionary area?
I have not had discussions. I'm unaware of if other someone else in the company has.
Are you aware?
The only discussions I would have had is putting together comm agreements.
And have you put together a comm agreement, a singular comm agreement that covers this entire area but excludes that exclusionary area?
Yes, sir.
And has it been submitted to the, or have you, I suppose it hasn't been submitted to the BLM pending this order, is that correct?
It's still out for execution. I plan to submit it here soon. I haven't gotten all of the signatures back yet.
Are you aware of any other COM agreements that is similar in nature to this one, where there's two non-connected areas being submitted in the same COM?
There's not one that comes to mind.
Do you include anywhere within your exhibits where the pause points and resuming points are for the perforations for the proposed wells?
Not beyond the fact that the east half northeast of section 23 is the excluded portion, and the remainder of the north half of those three sections is included in the proration unit.
Has Mewbourne considered drilling U wells instead of 3 mile wells with missing completed lateral?
I would have to defer to the technical team on that. These wells were, planned this way, and to drill the I guess it'd be 2.75 mile laterals, and the excluded portion is so that we don't interfere with that existing second Bone Spring well that you see on the exhibits.
And in regards to the technical team, is the geologist that we have available a part of that team?
It would be him and an engineer, but yes, the geologist would be part of that.
Are you aware of any discussions associated with potential pad locations if a U wells were to be drilled for that west unconnected area?
I'm not aware of discussions regarding drilling any U-turns.
Has Mewbourne drilled U-turn wells in the past?
Not to my knowledge.
This particular case is limited to only the second Bone Spring, is that correct?
That's accurate.
What is the status of the rest of the Bone Spring for this area?
As far as...
Okay, let me re-ask my question. In regards to completing wells, or at least proposing wells, what is the status for the rest of the Bone Spring in this area?
I'm sorry, I'm still not sure I understand the question.
Yeah. Let me ask it again and maybe provide a little additional context. Are there other compulsory pooling cases for this same area that is for the Bone Spring 1, for instance?
I'm not sure if there is or not. I set it up as to pool the second Bone Spring because in potential future developments we've talked about, we would have potentially a differing proration unit. So I thought it made the most sense to pull the north half of these three sections, excluding that east half northeast of section 23, but do it as to the second Bone Spring only, and then have another case for potential future developments that might have a different proration unit.
Now, is the only reason to vertically limit this case to the Bone Spring 2, is the only reason for that is because of that existing horizontal well? That's within that excluded area?
You're asking if the only reason to limit it to the second Bone Spring is because of that existing second Bone Spring well?
Yeah, let me re-ask my question. Is the reason this is only limited to the Bone Spring 2 because of that horizontal well in the excluded area?
No, sir. I mean, the reason for limiting it to the second Bone Spring was, as I said, to for potential future developments that may involve different proation units or benches. Like if we were to drill a different bench in the Bone Spring, it could potentially be set up with a different proation unit. I guess that it would be the reason then, because the existing well is the second Bone Spring and you're not wanting to interfere with that. So
Okay, let me re-ask my question because I think you might have changed courses a little bit in the middle of your answer. So then is it accurate to say that the reason to limit this to the Bone Spring 2 is because of that existing horizontal well in the exclusion zone?
yes.
Okay. So you referenced different paration units for the other zones. Would it be accurate to say that those other considered paration units would be the north half of these three sections, but include that excluded area? Is that accurate?
That could be a potential development plan.
Okay. Are you aware of any depth severances within the Bone Spring within the proposed unit?
I'm not aware of depth severances.
Okay, and considering the excluded area, are you aware of any depth severances within the Bone Spring in that area?
Outside of the excluded area?
Within the excluded area, are you aware of any depth severances within the Bone Spring?
No, sir.
If I were to ask you to amend the Form C-102 to include the pause points and resumption points for the perforations, do you understand what I'm asking for?
Yes, the first and last perf outside of the excluded area is what you're asking for.
Yes, essentially I want to know where you're pausing it before you go into the exclusion area, and then when you're resuming perforations when you leave the exclusion area. Does that clarify?
I believe so.
Okay, thank you, Mr. Bradford. Mr. Hearing Examiner, if I could question the geologist now.
Okay, and who is that, Miss McLean?
Charles Crosby.
Okay, Mr. Crosby?
Working. Sorry, my computer was not connecting, so I'm in the office next to Braxton, so I'm using his.
Perfect. Would you raise your right hand? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes.
All right, you can put your hand down. How do you spell your name, please?
Charles, Charles, Crosby, Crosby.
Have you been accepted as an expert before this division?
Yes, sir.
In what field?
Geology.
Okay. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Crawford.
Crosby.
Crosby, excuse me. I apologize.
You're good.
Sending a message to Mr. Lowe. Mr. Crosby, if I could draw your attention to your cross section in Exhibit B3.
I can share
Yes, sir.
that. Give me a second. I'll share the screen.
Yeah, I think it's, oh, I guess I don't have a page wrote in my notes. I just have Exhibit B3.
It's page 32 of the PDF. I'll share the cross section here. Let me see if I can fit it to one screen. Okay. Is this what
Are
you're
you
looking at, Mr.
Yes,
McClure?
it is. Yes, it is, Miss McLean. Thank you. Mr. Crosby, are you seeing what Miss McLean is sharing on her screen?
Yes, sir.
Do you see that that little map that shows your A to A prime that's overlaying that cross section towards the bottom left there?
Yes, sir.
Can you remove that? If I asked you to remove that and submit an amended cross section without that, do you understand what I'm asking for?
Yes, you would just like me to take the reference map off the cross section.
Yes, it is accurate to say that that exact same reference map is in the preceding page to this one, in the exhibit, correct?
Yes, sir.
And I know I've made this comment to Mewbourne in general at least once and in about 3 to 4 dozen different cases. Is there any way that you can communicate to the rest of the geologists within Mewbourne's team to quit putting that little map overlaying their cross section?
I sure can.
Okay, thank you. Mr. Crosby, were you a part of the team that was making the decision between doing a 3-mile well versus a 2-mile well and a U well?
Yes, sir. I was part of the team that put together this well plan.
Was a U-turn well proposed within that, or let me back up. Was a U-turn well considered by Mewbourne?
No, sir. Not to
Why
my
not?
knowledge. We feel like this is the best way to efficiently develop the acreage with a standard lay down horizontal.
Understanding that it hadn't been discussed then, here within the hearing, do you have a reason why you believe a single horizontal well would be better than having a horizontal well and a U-turn well?
I apologize. You were breaking up in the first part of your question. Could you please repeat?
Okay, I sure will. I understand that the technical team hasn't discussed this previous to the hearing. But having said that, you being an expert here with us today, do you see a reason why a single horizontal well will be preferable to having a horizontal well and a U-turn well?
Having the single extended lateral horizontal well, we believe would, prevent waste as far as having, it's more efficient in our view. And as an operator that's been incredibly active in this part of the basin, we feel like we've got a pretty good grip on the most efficient way to develop these reservoirs.
Now, when you reference prevention of waste, are you referring to recovering hydrocarbons or cost efficiency?
I would say both. I mean, we think this is the best way to efficiently develop the reservoir. And I think our track record, in this part of the basin, we feel confident in that assumption.
Now, you reference both recovering hydrocarbons and efficiency. Can you elaborate on how it increases hydrocarbon recovery?
I guess what I was alluding to in that statement is we feel like this is the most effective and proven way to develop the Second Bone Spring sand in this area.
I guess, why do you feel a single horizontal well is more efficient to producing from the Bone Spring 2 in this area versus a horizontal well for the east portion and a U-turn well for the west portion?
I guess I would say that you have less surface locations. You're drilling a single well instead of I guess in your scenario, not ours, instead of two milers and a Uzonal in the western portion of section 23. I mean,
Okay, but since this wasn't considered by Mewbourne, I guess clearly there hasn't been any cost analysis or anything like that done between the two scenarios. Is that correct?
not to my knowledge.
I asked Mr. Branford or your guys' landman just a bit ago about the rest of the Bone Spring in this area and possible proposals for the Bone Spring 1 and the Bone Spring 3 as such. Are you aware of the status of any other wells proposed Bone Spring in the area?
I'm not.
Okay. Thank you, Mr. Crosby. Mr. Hearing Examiner, I don't think I have any more questions for the experts, but I do wonder if we may want more from Ms. McLean in regards to if we have any prior orders that she's aware of that the division has even issued in something similar to this.
Ms. McLean?
I mean, I think that that's not really properly before the examiners at this hearing because we have separately as is provided for in the rules applied for administrative approval of the non-standard spacing unit. And so perhaps that would be better done with Mr. Lowe. Because I'm sure he's the one reviewing that. All we've asked for is to pool this acreage. And I think that can be accomplished through this hearing and with an order from the division indicating that we have applied administratively for approval of the non-standard spacing unit. And then, the division can decide that question administratively. But there was no objection to our administrative application. So at this point, all that's needed for that is the division to decide. So I just don't think that whether or not approval of a non-standard spacing unit has been done or is appropriate is actually before the division today.
Okay, thank you. Mr. McClure, do you want to discuss this offline or how do you want to proceed?
I guess if I can re-clarify my question to get one more response from Ms. McLean,
Sure,
maybe.
go ahead.
Ms. McLean, I guess a question, maybe I can re-clarify my question here. Are you aware of any other compulsory pooling order that the division has issued where it has two different areas that's not connected within the same order?
I am not. I don't think anyone is.
Well, I mean, I guess that's yeah, I was wondering if this is precedent setting, I guess, is where I'm getting at, or if like the OCC or the division has ruled on this concept in the past, or if this is the first time it's even been before us.
I think Ms. McLean has given you her answer. Do
Yeah,
you
she
want to
has.
discuss this off? Why don't we take 5 minutes and discuss this offline? So we're going to have a 5-minute break. It's 10:24. We'll come back on the record at 10:29. Thank you.
Thank you.
All right, Mr. McLean, we are back. It is 10:29 a.m. on the 13th of November. We were just discussing your case. We will take it. No, we won't. Ms. McLean, please submit a revised hearing packet without the overlay.
Oh, for Exhibit B3.
Yes.
Okay, great. Yes, and I was just saying, just for clarification, Mewburn has done this before. I believe we're looking, it's the Parkchester wells. We're not sure if it was pooled acreage, but we are trying to get the APDs and things.
Okay.
But we can submit all that to Mr. Lowe
Perfect.
if he has
Perfect.
questions, so we can clarify that. And in the
Let's do
meantime,
this, Ms. McLean, let's do this. This case has to come back so that Mr. McClure can review the exhibit without the overlay. Why don't you continue this case to the November 18 docket? Not sure what time that'll start. Probably won't start at 9. Probably will start 10 or 11 or something like that on next Tuesday. In the meantime, that gives you some time to explore any other cases that the division has granted this type of compulsory pooling application. You can search through the database of orders if you like. It'll give Mr. Mr. McClure some time to do some more research as well. And please have your witnesses available, the geologist and the landman, just in case he has questions next Tuesday.
will do.
All right, perfect. Then, and with that in mind, we will continue, you will continue this case to November 18 to continue the evidentiary hearing, and we are off the record in this case.
Thank you.
Thank you. Let's move on now. It's 10:30 now. Let's move on now to Longfellow Energy. This is case number 25635.
Good morning, Mr. Hearing Examiner and Mr. McClure. Samantha Catalano of Spencer Fane, representing Longfellow Energy.
Good morning.
Good morning. And I don't believe we have any other parties here this morning, Mr. Hearing Examiner.
Wonderful. And so did you enter an appearance? Was it Ms. Shaheen and now it's you?
Ms. Shaheen is still counsel for Longfellow Energy, and I did enter an appearance yesterday.
Oh, perfect. All right, thank you. How do you spell your name, since we don't, we've not heard from you before?
Certainly. It's Samantha, Samantha, Catalano, Catalan as in Nancy O.
Okay, and are you in the Santa Fe office?
Yes, I am.
All right, very good. Okay, so why don't you present your case? Have you seen how we do it here by affidavit?
Yes, Mr. Hearing Examiner, and this is my second time presenting before the division.
Okay, go right ahead.
Thank you. In this application, Longfellow seeks to pool all uncommitted mineral interests in the Yeso Formation in a standard 640-acre, more or less, horizontal spacing and proration unit comprised of the north half of Section 24, Township 17 South, Range 27 East, and the north half of Section 19, Township 17 South, Range 28 East in Eddy County, New Mexico, to drill 5 2-mile wells in the well family Bonzo 1925 Federal Com ABX. We submitted our application package on November 6th, which contains the self-affirmed statements of landman Stuart Gaston as Exhibit A and geologist Jacob S. DeHammer as Exhibit B, both of whose credentials have been qualified and accepted by the division as experts. Both are also here to answer any questions that the division may have. The self-affirmed statements of Mr. Gaston and Mr. DeHammer have the usual exhibits attached. We timely sent out notice to all interested parties on September 19th, 2025, and also published notice on September 23rd, 2025, which was timely. All of the notice materials are contained in Exhibit C. I now respectfully request that the exhibits be admitted into the record and that this case be accepted under advisement at this time, and I will stand for any questions.
All right, thank you, Ms. Catalano. Can you tell me the experts, have they been previously qualified by this division?
Yes, Mr. Hearing Examiner, they have been.
Both of them?
Yes, sir, and they are also here as well.
Perfect, thank you. All right, without exception, Ms. Catalano, Mr. McClure, questions?
Oh, thank you, Mr. Hearing Examiner. I do have questions for the landman.
Great. Would you call your landman?
Yes, I believe that Mr. Stuart Gaston is on the line with us.
Yes. When you turn your camera, there we go. Okay, would you raise your right hand? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Thank you. You can put your hand down. Spell your name for the record.
It is Stuart, Stuart, Gaston, Gaston.
And you've been previously qualified as an expert before this division?
Yes, sir, I have.
In what field?
In petroleum land management.
Perfect. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Gaston, are you familiar with the interest that may be owned by Cannon Exploration Company?
Yes, sir, I am.
Can you provide a little bit more details, I guess, about that potential interest?
Yes, sir. We believe that it's a contractual interest across the west half of Section 24. Specifically, their interest derived from the southwest quarter of the section, which is not a part of this compulsory pooling order.
So then they don't own an interest in the proposed unit?
We're still examining it, sir. Going to have to wait till our divisional or title opinion comes out, but we included them on the notice as a catch-all. They did not own a leasehold interest in the northwest quarter of Section 24.
But did I hear you correctly that you're still doing research into the matter then?
Yes, sir, we are. And we will
when do
defer
you,
to. Mhm.
when do you think that research will be concluded?
Shortly, sir. We've submitted our all of our title material to our division order or title attorneys, and we'll be having an answer, in short order.
Now, not a specific time frame, but just like a magnitude of time. Are we talking like tomorrow, next week, next month, 6 months from now?
Course of business of getting the division or title opinion, maybe 4 or 6 months. If the court needs us to have an expedited answer on this particular matter, we can certainly request that from our title attorneys, and might have a expedited answer quicker than the 4 to 6 month time period.
Okay, now of the interest that Canon may potentially own, who are you contributing that interest to currently?
Currently, sir, bear with me. It would be the other owners in that contract area, particularly Andrews Oil, Pinrock Oil, and I believe it was Hillcorp. So if you can, I'm looking at the exhibit page right now, sir. It would be tracked or unit track 7. So Riley, sorry, I said Hillcorp, I meant Riley. I apologize. Andrews, Pinrock, Longfellow, and Riley. In unit track 7 on, I guess that is page 30 of 113.
Okay, thank you, Mr. Atson. I do see what you're referring to. Like this is like your table of interest for each of the different tracks. There's 5 different persons listed there, correct?
That is correct, sir. Yes, sir.
So then, if they own an interest, how much interest would that be?
It was, I think similar interest to Andrews and Pinrock. So.
Okay, I see in your foot. Oh, go ahead, sir.
Oh, sorry. Maybe sub, a small interest. Yes, sir.
Okay, I don't say I see in your footnote at the, like just below this table, you reference 10% of the interest shown in record in Scott Wilson and Richard Barr. Does that mean that they potentially own 10% of what you're contributing to somebody else here or not?
No, sir. I believe that interest was
Okay.
split up between multiple parties. That 10% was split up into multiple parties.
Okay, so is it potentially that they owned a total of 10% in that track? Is that correct?
I'd have to go back and look, sir, but I do not believe it was as high as 10%.
But of whatever percentage they potentially own, currently you just have it split out equally among the other owners. Is that correct?
I would need to investigate further. And again, we'll have a title opinion that completely identifies the ownership there.
Okay, I guess if I were to tell you that the information I would like to see is what interest is in dispute currently. If I were to ask you to provide us with some sort of supplemental or in addition to one of these existing exhibits that kind of breaks that out, do you understand what I would be asking for?
Yes, sir, I do. And I can pull up some ownership reports right now to try and give you the correct answer. If you'll bear with me for 2 seconds, I'll pull it up. Let me get back on this one, sir, and I can give you a correct answer.
Okay, Mr. Gaston, it looks like there's an incorrect pool included on the Form C-102s. If I were to ask for those to be amended to include the correct pool, do you understand what I'm asking for?
I can certainly relay that to a regulatory group and get those corrected.
Very good. And if you have a pen and paper, I can provide you with that pool code and pool for that.
Absolutely. Yes, sir.
Okay, the correct pool would be the Red Lake, Gorieta Yezo, Northeast. And the pool code for that is 96836.
836.
Yes, sir. Mr. Hearing Examiner, I don't have any further questions. Oh, thank you, Mr. Gaston. Mr. Hearing Examiner, I don't have any further questions for the experts. I'd only ask that they provide that supplemental exhibit we were just discussing and correct it Form C-102s.
Okay, and Ms. Catalano, can you do that by tomorrow close of business?
So Mr. Hearing Examiner, just to confirm, the request by tomorrow close of business is for the supplement to the exhibits that discusses the breakup in interest and the dispute, and also the corrected C-102, is that correct?
Mr. McClure?
Yes, that is correct.
Ms. Catalano?
I believe that we can do that by tomorrow close of day. Yes, sir.
All right, so the case is not taken under advisement yet. We need that amended exhibit packet with cover letter with those changes that you just confirmed with Mr. McClure. And you need to move this case to the November 18 docket if you want us to hear it again in a timely fashion.
Understood, Mr. Hearing Examiner. And Mr. Hearing Examiner, to move the case to that docket, should I file a motion requesting that?
I believe that's how it works. Freya, do you would you give her some information?
Yes, it is a filing. There's $150 filing fee for a motion to continue, and it's submitted as other filings are through the permitting portal.
Okay, thank you.
And then the Freya, is the amended exhibit packet that she's filing, is it also filed at the same time as the motion to continue, or is it a separate issue?
It would be a separate filing.
Okay. Okay. And Freya, if she filed the exhibit packet by close of business 5 p.m. tomorrow, there's no fee for that, right?
There are only fees for the motion to continue and the application to initiate the case.
All right. If she filed the motion to continue on Monday, would that still get it on Tuesday's docket?
I would like to prepare a worksheet on Monday, so if she could file it early Monday, no later than noon.
All right. Okay, Ms. Catalano?
Yes, thank you, Mr. Hearing Examiner.
All right, we're off the record in this case. Thank you. Moving on to Mr. NM Operating 25642.
Jackie McLean on behalf of MRNM.
Thank you.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of MAC Energy Corporation, and we are objecting to this case moving forward.
All right, we received your objection. I think it was yesterday.
Correct.
All right. Now, this was a case in which we've seen this case before, and was there an objection before when we heard it in October, or is this the first objection?
No, there was an objection and we withdrew it in good faith. However, those negotiations stalled out. And so we have renewed our objection and we would ask that this be set for a status conference along with our case, which is set for a status conference next week, so we can discuss scheduling a contested hearing.
And what is your case number, Ms. Vance?
Oh, I wrote down, it's 25698.
Freya, would you join those two cases?
Yes.
All right. Ms. McLean?
Yes, and we filed an objection to that case already. And we would just like to see this get set for a contested hearing. We didn't want to mess around to begin with, and we don't want to keep doing it now.
Okay. So, Ms. Vance, I know that your case is coming up. When did you say it was coming up?
It was, well, we did file it for this hearing. However, as Ms. McLean said, she objected, or Mr. New Mexico objected. And so it's on the status conference for 11/20 next.
I see.
Correct,
Okay.
next week.
Well, I know that we'll hear your case then, but why don't we discuss possible, I mean, you have 3 dates. You have 2 dates in January that Ms. Chance sent out earlier. And you have 1 date in February. So I'm going to start with Ms. McLean. Ms. McLean?
The earlier, the better.
Right. I figured you'd say that, yes. That'd be the January 13 docket. It's a trailing docket. There's already 3 cases on it, if I'm not mistaken. But you know how these cases go. They evaporate as we get closer to the hearing date. They miraculously evaporate. So, Ms. Vance, January 13?
No, we would like to push out to the latest possible date, which is that February 10th. And so I would like to, I'm not sure if Ms. McLean is aware, but MAC has had several conversations with XTO. They've been meeting with XTO, who is the interest holder for the contested overlapping acreage. And MAC is looking to acquire that acreage. But now it's my understanding has verbal support from XTO. And so, I would like, the reason why I'm asking for the latest possible date is similar to how we withdrew our objection before to engage in good faith negotiations. We would like to allow for time for the parties to negotiate. And so perhaps maybe Ms. McLean can take that information and talk with her client, and we can maybe agree to a later contested hearing date, at least later than that first initial one in January.
Ms. McLean,
I think, we are not of the same opinion that Mac is trying to negotiate in good faith, that we have our own sets of discussions. Everyone's discussing everything. This is why we just need to get it set, put it all out there in front of the division. It will all come to light, I'm sure, as we get closer. If they are discussing, then we'll do a deal. If they aren't, then let's get the division to weigh in on it. So MRNM has been trying to get this set for hearing. MAC only filed their application after we'd already filed ours. And we would like to get this set on the January 13th hearing date. If we can come to an agreement, great, but let's put pressure on everyone and let's get this set. We're tired of the delay.
Ms. McLean, when was your case filed?
Our case was filed. Let me get the original. Sorry. Got lots of screens open today with the various hearings. Gotta get my screen 2, 5, 6, 4. Yep. We filed our application on September 9th.
Okay, September 9. And that means you sent out well proposals a month before?
I believe they were sent out even before that. Honestly, I can find that for you if you give me 1 second.
Yeah, sure, go ahead. I'm curious how long MAC has been aware of your proposal.
Well, we would not have received it.
Yeah, because they don't own an interest in our acreage.
Similar to MRNM would not have received our proposals because they don't own an interest in the overlapping acreage either.
I understand. I remember that now. So Miss Vance, Miss McLean, you don't need to tell me when you sent out well proposals because of what Miss Vance just alerted me to and reminded me of, that neither party has that overlapping acreage interest. Ms. Vance, when did you become aware of MRNM Operating's proposal?
So myself getting involved was at the end of September. Okay. It looks like. And may I just add one thing regarding the negotiations? Sure. So MAC has engaged in good faith negotiations. They did reach out to MRNM, but the only feedback that MRNM provided was telling MAC that they needed to shorten their laterals rather than having any sort of fruitful negotiations. And that is not fruitful negotiations for the parties to try to accommodate one another. So that's not true, and that's where the negotiations stalled out. Now, again, I think I understand that they want to move forward. We would like a later date, so I would propose split the baby and let's agree to the January 27th date.
Okay.
Miss
McLean had hold on, Ms. Vance. Ms. McLean, had you heard about that? What Ms. Vance just added about the negotiations?
I mean, I think that that's true that the MRNM proposed that. However, Ms. Vance has told me so many times, like, oh, they've been reaching out, and MAC has not continued to reach out. I do think that MAC was aware of these proposals well ahead of this hearing because they are related by blood or company structure, something to Chase, who holds an interest. And that's how MAC got tipped off on this, and they wanted a piece of the pie too. So there are some other dealings happening kind of behind the scenes, and MRNM had begun talking to Chase a year ago, a really long time ago. And they have had discussions with Chase, who did own this interest. Now it is like reverted to XTO through contract stop. It's all very, very complicated. So this has been going on for some time, which is why, we want to get it heard. And asking someone to split the baby happens all the time. The division even asks people to do that in their orders. So, we're available at any time. I would like to get this set as soon as possible. This has been dragging on. Mac entered an objection, at the hearing, the day before the hearing, the last go around. Now they've done it again. Like, when is this going to end? So let's just get it set. I'm sorry if they want to stall further, but I just don't think that's acceptable.
Okay. I've heard from both parties. I've made up my mind. Miss McLean, I'm going to set it for the second docket in January, the 27th. However, if witnesses are not available, then I'll set it for the 13th, but I will not set it for the February docket. So it is up to the parties to notify the division. We'll issue a pre-hearing order. We will join both cases together for the pre-hearing order. It'll be January 27 will be that hearing date. But if parties let me know that their witnesses are not available on that day, we will pick the alternate day, which will be the sooner day of January the 13th. Ms. Vance, anything further?
No, that works for us. Thank you.
All right. And just to let the parties know, I won't be continuing this hearing. This is, as Ms. McLean said, has been ongoing even before it got to the division in September. It's been 2 months now. It'll be another 2 months, so this will be on our docket for almost 5 months. At that point, it's getting old. So anything further, Ms. McLean?
No, thank you.
All right, thank you. We're off the record in that case. Let's move on to Civitas Permian. These are two cases, 25644, 25651.
Thank you, Mr. Hearing Examiner. Gabrielle Gerholt on behalf of Civitas Permian Operating, LLC, and no other appearances have been entered in these matters.
I agree. Go right ahead.
Thank you. In case number 25644, we are requesting an additional year to drill the Modelo 2223 FedCom 211H that has been dedicated to a standard 640-acre horizontal well spacing unit within the Purple Sage Wolf Camp gas pool in the south half of sections 22 and 23, Township 24 South, Range 26 East, Eddy County. In case number 25651, we are also requesting an additional year to drill the Modelo 2223 FedCom 131H that has been dedicated to its standard 640-acre horizontal well spacing unit within the Willow Lake Bone Spring West, which is limited by a Bone Spring Formation depth severance from the stratigraphic equivalent of 8,062 feet to the base of the Bone Spring Formation in the south half of sections 22 and 23, again, Township 23, 24 South, Range 26 East. The evidence packets for these cases include copies of the applications, the original pooling orders, the self-affirmed statements of landman Gianna Romero. Ms. Romero has previously testified and has been recognized as an expert before the division, and she is available today if there are questions. Ms. Romero's statement is Exhibit C and includes all the standard land exhibits. Exhibit D is my self-affirmed statement of notice with a copy of the letter that was timely mailed on September 17th, 2025 to all interest owners within the unit. In addition, we published notice, and you'll find our notice of publication affidavit included as Exhibit E, which was timely published on October 2nd, 2025. And unless there's any questions, I would respectfully request that all exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement.
Thank you, Ms. Gerhold. Admitted without objection and taken under advisement for both of them. Thank you.
Thank you.
Moving on to Mewbourne Oil. This is number 19 on our docket. It is 25648. It is joined with 25649 and 50.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Mewburn Oil Company. And I just wanted to draw attention. Did you say you need to stop at 11?
11:30, thank you.
Okay, okay. I just wanted to. Okay, in
I
all
believe
three
we
of
have
the.
another entry of appearance in your case ending in 5-0.
Yes, we do. Mr. Holliday. I think
Hey
he
guys,
was on me.
can you hear me? Apologies, didn't know that these were combined together. Ben Holiday, entering an appearance on behalf of Ichthys Energy in case number 25650 only. We're just observing.
And how do you say the name of that energy company?
I knew you were going to ask that. Yeah, Ichthys. It's a
Okay,
Greek word.
thank you, sir. I couldn't
Um,
help myself.
yes,
All right,
sir.
go
Yeah,
ahead, Ms.
I
Vance.
believe me, I've asked many times.
Ms. Vance.
Oh, thank you. Okay, so in all three of these cases, we're just opening to pool additional parties. So in each of the application or each of the hearing packets, rather, we included a copy of the applications, the original orders, and those dates are various between June and July of this year. And then we also included a statement from our landman, Peyton Warren, who has previously testified before the division, and her credentials have been accepted as a matter of record. We included a land tract map, a updated pooling exhibit,
Ms.
as well
Vance,
as
we know what's in the packet. Thank you. Let me ask you a question about the notice.
Sure.
Is it timely?
It is timely.
When did you send out notice?
Notice went out on the letter September 19th, 2025. I almost said 23.
And publication?
Publication was between September 23rd and 25th across the three different cases, 2025 or
Perfect.
2025.
Then we'll admit your exhibits without any protest, and we'll take your three cases under advisement.
Thank you.
Mr. Hearing Examiner, before we
Sorry,
take one of the cases.
Sorry, Mr. McClure?
Mr. Hearing Examiner, before we take one of the cases under advisement, can I ask a clarifying question of Ms. Vance for it?
By all means, which case are you asking
This
about?
case, docket number 20, case 25649.
Go right ahead.
Thank you, Mr. Hearing Examiner. Ms. Vance, there appears that notice was conducted September 19th and then again on October 24th for this case. Is that accurate?
Yes, and I believe it was because there was an updated address. That's correct. There was an updated address for one of the parties in Mewburn, and that's Miss Carol Shumate, Shumate. And my understanding is that the landman is in communication with that party.
Okay, and the notice spreadsheet for the October 24th notice, this would be the second one, the one on page 31 of 33. Is that correct?
Correct, and it's showing that it's delivered and signed for.
Okay, thank you, Ms. Vance. Thank you, Mr. Hearing Examiner. That was the only clarifying question I wanted on the record.
Thank you. Okay, Ms. Vance, we're off the record in those three cases. Thank you.
Perfect.
I'm now going to move to some more of your cases. These are Matador Production. There are several cases. I'll read the case numbers. 25652, 53, 54, 56, 57, 58, 59, and 60.
Good morning, Mr. Hearing Examiner, Mr. McClure, Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant MRC Permian Company. These are all extensions, and I believe that that Hardy McLean has entered an appearance on behalf of a party.
Good morning, Mr. Hearing Examiner. This is Yaritza Pena with Hardy McLean on behalf of PBEX LLC, only in case 25653, and we are not objecting, we're just monitoring.
All right, perfect. Ms. Vance, these cases look good. Why don't you give me a sentence or two about them so we can take them under advisement?
Okay, there are extensions. There's no objections. Notice was timely. September 19th, 2025 for the letter, and affidavit was September 25th through the 26th for all of the cases 2025. Unless there are any questions, I would ask that the exhibits and the statement be accepted as a matter of record and the cases be taken under advisement.
Thank you. Mr. McClure, you don't have any questions, do you?
Mr. Hearing Examiner, actually, I do have a quick question for these cases for the landman before we take under advisement.
All right, sounds
Okay.
good. So who is your landman?
It is Isaac Evans, and I know he's on here.
Perfect. So
There he is.
we receive your exhibits into evidence without objection, Ms. Vance. And now there you are, Mr. Evans. Would you raise your right hand? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
I do.
Thank you. You can put your hand down. Would you spell your name, please?
Sure. First name Isaac, ISAAC. Last name Evans, EVANS.
Okay. And you've been accepted as an expert by this division?
Yes, sir.
In what field?
Petroleum land.
Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Evans, for these cases, it looks like it is the first request, but what is the reason for the request?
Sure. So we're drilling some wells immediately adjacent to this unit coming up here in a month or two. And we feel it was prudent to monitor the results of those wells to give ourselves more time before drilling these wells.
Okay, thank you, Mr. Evans. No more questions, Mr. Hearing Examiner.
Thank you. Ms. Vance, their cases are taken under advisement. Okay.
Excellent. Thank you.
You're welcome. Let's go on to number 31 on the docket. This is Mewbourne Oil 25662 and 25661.
Mr. Examiner, Jim Bruce representing Mewbourne.
Okay.
Mr. Examiner, in the first case, Mewbourne seeks to force pool the north half equivalent of sections 5 and 6, 18 south, 31 east, for purposes of drilling 3 first and second Bone Spring wells. That is shown in the pooling checklist marked Exhibit 1. The rest of the exhibits are the normal exhibits. Exhibit 2, the landman's affidavit. Exhibit 2B contains the plats, the interest owners, and the pooled parties. Exhibit 3, geologist affidavit, contains the usual structure and cross sections. Exhibit 4, the affidavit of certified mailing. Exhibit 5, the affidavit of publication. And Exhibit 6, the application and proposed notice. I believe the exhibit package is correct. I would note that certified notice was sent on September 18th. Publication notice was done on September 25, so notice is timely. One thing is that as of last Thursday, I had finally received back all of the green cards from the parties being notified. I was going to submit a revised exhibit package to show that. I decided to hold off to see, just in case Mr. McClure had any further requirements of Mewbourne. But with that, the exhibit packages are complete. I would ask a couple of days to submit the green cards. But with that, I think the exhibits should be admitted and the case is being taken under advisement. In the second case, the only difference is that the south half of the two sections, sections and 5, are being pooled in the Bone Spring.
Okay, your exhibits are admitted without protest. Let's deal with the two cases separately. In 25661, you want to submit additional green cards, is that correct?
For both, the parties notified for both cases were the same. So it would just be one, it would be for both cases.
Okay, but we're dealing with them individually. So for 61, you want to submit additional evidence of notice. Is that correct?
That is correct.
All right, sounds good. So I don't believe Mr. McClure has any questions on this case, do you?
I do not, Mr. Hearing Examiner.
I didn't think so. All right. So Mr. Bruce, the way we're going to do this is we're not taking it under advisement, but we do have a November 18 docket. You can continue this case to November 18 as long as you file that notice evidence by tomorrow close of business.
Will do, sir.
All right. So that case, we will see again on the 18th after you continue it and file your evidence. Now, in case number 62, I know you also want to file additional notice evidence, and I believe you haven't signed your CPAC.
Yes.
So you agree with me?
Yes.
All right, very good. Mr. McClure, is there anything else about that case that we need? No. Okay.
No, sir.
So, Mr. Bruce, both cases must be continued to November 18 if you want them to be taken under advisement. Both cases have additional evidence to submit.
Yes, sir.
All right. Anything further, Mr. Bruce?
No, sir.
We're off the record in those cases. Thank you. Moving on to Mewbourne Oil, 25663.
Good morning, Mr. Hearing Examiner, Mr. McClure, Paula Vance with the Santa Fe Office of Holland and Hart on behalf of the applicant, Mewbourne Oil Company.
All right. Okay, let's hear the other entries of appearance. I'm sorry. Go ahead.
Good morning, Mr. Examiner. Carrie Hatley entering her appearance on behalf of COG Operating, Concho Oil and Gas, ConocoPhillips Company, and Marathon Oil Permian, monitoring only. Thank you.
All right, sounds good. Ms. Vance, before you begin, we have a legal description problem with this case. So why don't we deal with that first and see how we're going to address it? I don't think you need to present the case today. We need to deal with the legal description problem. Mr. McClure?
Yes, Mr. Hearing Examiner. Ms. Vance, if I can, well, draw your attention to any of the legal descriptions within the application, maybe the application itself or the landman statement.
I'm on the application.
Okay. Do you see where it says specifically for section 31, where it says lots 1 and 2, and then it says the west half of the northwest quarter, and then it says and the northeast quarter? You see where I'm referring to?
Yes.
Lots 1 and 2 is equal to the west half of the northwest quarter. Therefore, I believe what the applicant meant to include here was the east half of the northwest quarter, as that seems to be what's left off this legal description.
I would have to look at that and look at GIS, but if I'm remembering correctly, it was 1 through 4 going the west half, and that's why it's 1, 2, and then the west half of the northwest quarter, and then the northeast quarter. So I would have to go back and look at that, but that is my understanding on those reference to those lots. But in either event, it does correctly describe what is, the north half equivalent, which is what is being pooled here. So I don't want to, I would need a minute to pull this up on GIS.
Mr. Hearing Examiner, I wonder if we want to let her do that, or if it'd be faster to talk to the landman. I don't know what your thoughts are on the matter.
All right, Ms. Vance, do you have your landman?
Yes, Ms. Rodriguez should be on the line. I am not seeing her. Oh, there she is.
Good morning, Ms. Rodriguez. Would you raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes.
Thank you. You can put your hand down. Would you spell your name, please?
Ariana Rodriguez. It's ARIANA RODRIGUES.
Thank you, Ms. Rodriguez. Have you been accepted as an expert before this division?
Yes.
All right. In what field?
Petroleum and Land Management.
Very good. Mr. McClure?
Thank you, Mr. Hearing Examiner. Ms. Rodriguez, do you see the legal description that I'm referring to for section 31 of Township 18 South, Range 32 East?
Can you confirm the page?
It should be within the application itself. I think that's on page 8 of 63, if my notes is right here anyway.
Yes.
It looks like Ms. Vance is sharing PLSS there too. But do you see the legal description I'm referring to, Ms. Rodriguez?
Yes.
Ms. Rodriguez? Okay. Do you believe that where it states west half of northwest quarter, do you think that's accurate?
It would be lots, let me see, 1 and 2, east half of the northwest and the northeast quarter, which would be that north half equivalent.
Okay, so do you agree that the legal description that's within the application is incorrect then?
I think we have a typo on a portion of it, but it says the north half equivalent.
Mr. Hearing Examiner, I don't think I have any more questions for the expert, unless you want me to elicit additional evidence, I guess.
Well, it's up to you. We need to make a decision about the notice here.
I guess to lay it out, they do have where it says north half equivalent, which is what they're asking for, is the north half equivalent. But when they lay out the individual description for that north half equivalent, they mistakenly included the west half of the northwest quarter when they meant to include the east half of the northwest quarter.
I'm looking at what is this marked at? What exhibit is this, Ms. Vance?
So this is in the application. It is also in the compulsory, in the CPAC, and then it is in Ms. Rodriguez's statement. So again, I would reiterate what Ms. Rodriguez said, which is it does reference the north half equivalent, which is, you know, encompassing all of what is being described there. And it's just a simple scrivener's error. And that's why we provide contact information in all of our notice in case there is any issue with any of the information that's provided in the application and in the notice. So
thank you, Ms. Vance. What I asked was, what exhibit number is this?
So it would be a couple of the exhibits. So it would be Exhibit A, it would be Exhibit B, it would be Exhibit C.
Can I have the exhibit back?
You want me to put it up here? Yeah. So this is Exhibit B, which is the application. And you can see this should be east half of the northwest quarter. But
and you're saying that the information in the parenthesis would then conflict with the legal description where it says west half.
It is providing the totality of what is being described. But
can you go back,
Ms.
Vance?
Disagree.
What I wanted to see, thank you for showing me this, but I wanted to see that map again. Can you go back to the map?
Sure.
All right, perfect. Now, where is the area on this map that you want to compulsory pool?
It is this from 35 over to 32. So from here, this entire acreage right here.
Okay, I guess on that, unfortunately, I'm still confused. This north half equivalent, these are whole sections, are they not?
These are whole sections, but what is being described is, I mean, specifically in reference to that north half is this north half of 31 right here.
That's it. So the north half of 31. And what does the legal description, the erroneous legal description say?
It has lots 1 and 2, and it has the west half of the northwest quarter, which is these lots 1 and 2, and not the east half of the northwest quarter. And then it's got the northeast quarter. So that one piece should say the east half of the northwest quarter. But again, it's a scrivener's error.
Hold on, Ms. Vance, don't keep saying the same thing because it's not helping. So I don't understand something. If this is the north half equivalent, why doesn't it say, correct me where I'm going off the rails here. I know it says the northeast quarter of 31. Why doesn't it say the northwest quarter of 31?
Because because you have an irregular section, and so instead of these being units, which is the CBA that you see here, you see that these are lots, so they are less than the 40 acres that you typically see when you see the units right here. So like if you look at the totality of the acreage, it's going to be less than 40 acres right here. It might be less than or a little bit more, to be perfectly honest, but it's not a perfect 40 acres. And so that's why they're referred to as lots rather than units. Units are 40 acres based on.
But your legal description as it stands now is say it again so I can hear it.
So it has lots 1 and 2, and then it references the west half of the northwest quarter, which would be basically this again, instead of describing as the east half of the northwest quarter.
Oh, I understand now. I understand. So your legal description right now references lots 1 and 2. Then it reiterates lots 1 and 2 by saying the west half of the northwest quarter, basically leaving out the east half of the northwest quarter. And then it says the full 160 acres where it's the northeast quarter. And then it says northeast equivalent, one half of the north half equivalent.
Correct.
Okay, I understand where the problem comes from. To me, it's confusing. And it conflicts. Now, I realize that you're saying that, hey, you have contact information there and that people could call up and say, hey, what are you talking about? This doesn't make any sense here. But I have a problem with that description, and I know Mr. McClure does as well. So I know you're making the argument that north half equivalent saves the legal description. But when it comes to notice, I'd rather err on the side of caution than to say, well, people should understand it and that should be it. So I think you have a notice problem here, is my opinion. And what I'd like to know is what can you do to correct it?
Well, one thing I would like to add is there are no objections to this case. We have no objections. These have been sitting here for quite some time. Mewburn does have some timing concerns related to these, and so we do want to move forward as soon as possible.
Right.
If we needed to redo the notice, what I would ask for is that we will get that notice out as soon as possible. And similar to my other case, that we be added to the 12/9 docket. It's.
I have no problem with that. I have no problem with adding it to December 9 at all. So, by the way, was it Ms. Rodriguez? Was it you who developed the legal description, or was it Ms.? Let's just go with Ms. Rodriguez. Did you develop the legal description?
I would have to look through emails to see what I sent, but that was a mistake that I didn't catch. I'm sorry.
Oh, okay. But it falls upon you to come up with an accurate legal description.
It does fall. Well, okay. She sends it to me for me to review, and I didn't catch it. And
okay.
Caught it. But we also did have we sent overlapping spacing unit notice that has all the overlapping spacings, and it included the overlapping spacing in the east half of the northeast as well.
Okay. All right. I understand perfectly. And this exhibit is part of your testimony, Ms. Rodriguez?
Yes.
Okay. All right, very good. All right, so Ms. Vance, no problem with getting it on the December 9 docket. Please continue the case till then, and we will wait for an amended hearing packet with a cover letter to help us remember what happened here.
Thank you.
Thank you. Okay, it looks like we can do a couple more cases before 11:30. These are Permian resource cases, starting with number 33 on our docket, 25664, 665, 666, and 668.
Good morning, Mr. Hearing Examiner. Yaritza Pena with Hardy McLean on behalf of Permian Resources Operating, LLC.
I don't believe there's any other parties.
I believe that's correct, so I can
Go right ahead.
briefly present these. In case number 25664, Permian Resources seeks an order pooling all committed interest in the Avalon Formation and the third Bone Spring interval of the Bone Spring Formation, underlying a 482.26 acre, more or less standard, overlapping horizontal spacing unit comprised of the west half of sections 5, 8, and 17 in Township 22 South, Range 35 East in Lee County, New Mexico. And this unit will be dedicated to the Casa Bonita 5 Statecom 601H well. In case number 25665, we seek an order in the Avalon and third Bone Spring interval of the Bone Spring Formation in the east half, west half of sections 5, 8, and 17 in Lee County, and this unit will be dedicated to the Casa Bonita 5 Statecom 602H well. In 25666, we seek the same formation pooling order in the west half, east half of sections 5, 8, and 17, and dedicating the unit to the 603H well. And finally, in 25668, this is dedicated to the east half of sections 5, 8, and 17, and will be dedicated to the Casa Bonita 604H and the 104H wells. There are multiple depth severances within the unit, so Permian only seeks to pool from the top of the Avalon Formation at a stratigraphic equivalent of 8,724 feet to the base of the Avalon at 9,366, and again from the top of the third Bone Spring interval at a stratigraphic equivalent of 10,344 feet to the base of the third Bone Spring at a stratigraphic equivalent of 10,956. Permian is also seeking approval of those overlapping spacing units for each case. Exhibits were submitted timely for these cases last week and include the land testimony of Ms. Reagan Armstrong, who has previously been admitted to testify as an expert in petroleum land matters, and the geology testimony and corresponding exhibits from Chris Rudluber, who has also previously testified and has been admitted as an expert before the division. We finally include our notice testimony along with the copies of the notice letter that was sent to all interested parties on September 18th, 2025, and the notice of publication on September 21st. With that, I ask that the exhibits be admitted in case number 25664 through 66 and 25668, and that the cases be taken under advisement.
Admitted without exception. Mr. McClure, do you have questions for the landman or the geologist?
Both.
Okay. I see Miss Armstrong here. And
Yes,
then who is your geologist again?
The geologist, Mr. Rudluber, was unable to join us today, but we have Mr. Shane Harvey, who has also previously testified before the division and who would be adopting Mr. Rudluber's testimony and exhibits.
All right, let's get them both on the screen here with their cameras on.
Good morning.
Morning. There we go. All right. Please both raise your right hands. You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
I do. All right, please lower your hands. Would you, Miss Armstrong, spell your name?
Reagan Armstrong, ReaganArmstrong.
And you've been qualified as an expert before this division before?
Yes, sir.
In what field?
Petroleum land management.
All right. Your name isn't spelled properly here. So would you spell your name, sir?
It is Shane and then Jarvie.
Oh, it is spelled correctly. I guess I didn't understand it when Ms. Pena said it. Okay, is it Mr. Jarvie?
Yes, it's Mr.
All
Jarvie.
right, very good. And you've been admitted as an expert
Yes, sir.
Before this division?
Yes, sir.
As what?
Petroleum geologist.
All right, perfect. All right, Mr. McClure, who do you want to start with?
Landman's fine with me, Mr. Hearing Examiner.
All right, and I have one more question for the geologist. I'm sorry, I forgot to ask. I realize that you're not the original geologist who submitted the exhibits in the exhibit packet. That's what Ms. Pena said. But she also said that you have reviewed the exhibits.
I have.
All right, and that your expert opinion is the same as the original geologist.
That is correct.
All right. Okay. That's the basis that we're going to continue on.
Perfect.
All right. Mr. McClure, let's start with Ms. Armstrong.
Thank you, Mr. Hearing Examiner. Ms. Armstrong, is it accurate that Permian wishes us to force pull the Avalon Formation, skip formations Bone Spring 1 and Bone Spring 2, and then force pull the Bone Spring 3?
Yes, sir. There are already other pooling orders in those depths that you mentioned. That's why we're only looking to pool those depths that are uncommitted. So that will grab the rest of the Bone Spring for our